really for two reasons. One local and one, I would say, more national. So we have had instances, one in particular in the state, of a paramilitary training camp that is an operation that advertises its services to militias and other groups in and out of state, and is offering training in, I would say, coordinated assault, as you would train soldiers in combat. And so I was struck during the initial, press coverage of the Slate Ridge incident. I was struck with the administration's response. And I don't fault the administration because I believe in good faith. They searched the statutes for ways to control the situation and did not find them. So they were standing on stage saying to reporters, there's nothing we can do to stop a school that had been set up to train these kind of tactics, and the unintended consequences that the way that place was run was creating among neighbors who felt threatened and who brought forward evidence of these kinds of threats. So I started thinking at that time that there should be a relatively straightforward lever for the administration to use to shut down such an operation. So that was the genesis of the bill. It was introduced last biennium. In the ensuing time, we've had a lot more evidence of militia activity and paramilitary activity nationwide. For instance, threats to the power grid, among others, things that 20 years ago we weren't thinking about, even 10 years ago we weren't thinking about. So I understand that this is an area where we haven't been regulating, so we would be striking out a little bit into new ground. And I know that wording will be crucial because it has been my intention and will remain my intention that we not impact traditional hunting, target shooting, safety training, or any of the carved out operations that you see here, among them things like active shooter drills, hunter safety courses, etc. So with that said, I will turn it over to Eric for the walkthrough, but I do want to mention that one of the witnesses comes from a think tank at Georgetown that works on these issues. And as she will point out, there is a version of this bill that is in place in about half the states. And I think that's information that I didn't have before, that I found actually encouraging. And so my hope is that we can find an acceptable version of this bill, whether or not it's S3 as introduced. So with that said, Eric.
Thank you.
Yes, thank you. Good morning, everybody. Eric Fitzpatrick with the Office of Legislative Counsel to walk the committee through S3, which is an act relating to prohibiting paramilitary training camps. As Senator Baruch indicated, it is pretty straightforward in terms of language, and the definitions I think are important, but in terms of the language overall, it's straightforward. And I'll reference a couple of the other statutes when I get to, because I was in the same situation as Senator Baruch, that I didn't realize when we were putting this together that there were some other comparable statutes in other states that address similar kind of activities. It's interesting to find out later on. It sounds like you'll hear more about that later, but I also made the same discovery after this bill was put together. But going back to the language itself, as I mentioned, it's pretty straightforward. It's a prohibition on paramilitary training camps. Criminal prohibition, it's a 1-year misdemeanor. So in subsection A, your straightforward prohibition language, it just says a person shall not own or operate a paramilitary training camp or facility in the state of Vermont. There's your prohibitory language right there. As I mentioned, the 1-year misdemeanor is the second sentence in subsection A. That penalty is the same, it's quite common in the weapons statute. So the 1 year, $1,000 fine is pretty typical for the other statutes that deal with weapons in that part of the criminal code. So that's your straightforward what sort of behavior is not permitted under the statute, but you'll see subsection B next, we have a list of exceptions. So you move on, oh, sorry.
Before we get to the exceptions,
Yes.
So not operating a training camp, would this exclude paramilitary training activities if there was no fixed site?
I don't think so, not the way I would read it. I think that even as long as it was owned or operated by somebody, it might, as you say, move from one site to another or something like that.
Okay.
And the model bill, which should be up on our website, that the witness from Georgetown was going to talk about, actually gets more at behavior. So it talks about paramilitary activity like marching with insignias and weapons in the public square, that sort of thing. So this was limited exclusively to the facility, but that one covers a broader range of activity.
Thank you. So yes, so that brings us to the exceptions, and there's a number of them. You'll see the first one is basically law enforcement. There's an exception for training conducted by state or federal law enforcement agencies. The second one is military armed forces, whether it be Vermont National Guard of another state, or U.S. Armed Forces, but that's the concept there, the exception for armed forces training. Thirdly, fire department training, so state, county, or municipal fire departments. Over on the next page, next one, active shooter drills conducted by a school district. Another something that at least at first glance, if it wasn't an exception, might that come under that? So the intent there is to exclude that from being covered. Same thing with number 5, hunter safety courses, also excluded, either one approved by the Commissioner of Fish and Wildlife or equivalent hunter safety course approved by the Commissioner.
So, and I don't know if any of these operate in Vermont, but I know in New Hampshire, 6 Hour does a bunch of shooting safety courses and shooting courses that aren't necessarily hunter safety, but they're gun safety. Would that be covered by this exclusion or not?
If it's not related to hunter safety, I would read it as not.
Okay.
And that's certainly a change we could make,
Okay.
because I have had people contact me about that. I would like to say the heart of this bill is to increase safety, so
Yes.
we definitely wouldn't want to prohibit any kind of safety course.
Well, there's also every year at the Bennington Battle Day Parade and festivities, there's frequently cannons being shot off and people marching in the parade with antique weapons and fighting the drum corps and stuff like that. So I'm sure we don't intend to.
Yeah. And Chris tipped me off to, I thought typically historical reenactors did not have live weapons, but he tipped me off to the fact that they do sometimes have, they're antique weapons, but they can fire. So historical reenactment was not an issue for me with this either. So carving that would not be a problem. So you see what we're getting at. We're trying to create a series of exclusions, still left with the problem of how to most precisely define what we're prohibiting.
Yeah, exactly.
So continuing on through the exceptions, I think there's one more. Yeah, the last one, so is sport shooting conducted at sports shooting range. That is actually a defined term. You see it's at the very bottom of the definitions. It's defined in the Fish and Wildlife statutes. I just pulled that down so I can just read it to you really quickly. Sport shooting range or range means an area designed and operated for the use of archery, rifles, shotguns, pistols, skeet, trap, black powder, or any other similar sport shooting. So it's already regulated in the statutes and definitions there, so it just cross references to exclude those as well.
Quick question. So sports shooting conducted at a sports shooting range. If somebody is a sports shooter and they have several acres of property that they want to practice on, but it's privately owned, would that just be considered private property as opposed to a sports shooting range, and would they be able to practice on their own property?
It's an interesting question. I'm not sure right at the top of my head. There's actually this area of law, Michael Grady in our office of Fish and Wildlife stuff, and I got this definition from him, and he pointed us to that. So before giving an answer off the top of my head, there's a lot that I'm really not an expert in. I thought I'd check with him on that. But I will do that.
Yeah, thanks. Yep.
Maybe it'd be better to, well, we'll see the model law and hear more. It might cover some of our concerns, blah, blah. But go ahead, Eric.
Yeah, really just the last piece to mention is the definition of paramilitary training. That takes us through the exceptions. I already mentioned the definition of sport shooting range, which is the very last one. So what is it that's prohibited? It's paramilitary training that's prohibited. And that means instruction designed to prepare a person for combat through the simulation of military training and tactics, and that involves staged or simulated attacks on buildings, vehicles, or persons, or, and this is instruction, in the use of explosives, as defined elsewhere in Title 13. I should mention that that definition of explosives specifically excludes firearms. So explosives only, not firearms, that are prohibited here.
And I do think, having tried to think through some of the issues, people have legitimate concerns about self-defense. I think self-defense, is the individual thinking about how to use their weapon to protect themselves. What we're trying to get at here is coordinated activity where you're simulating a unit or a paramilitary grouping, and then learning how to coordinate with live weapons in order to be effective as a combat unit. That's the sort of authority that we only give to the military or first responders to train that way, it seems to me. So at a typical shooting range, I don't believe they're going to be teaching people to conduct group assaults on buildings. And the descriptions that I read from the Slate Ridge operation that was more what they were about was how to, as a unit, attack a car, a building, etc. And so it's the collective action with live weapons that's somehow at the heart of this, which is really combat training that they're not authorized to give.
I have a question. I guess it's kind of a rhetorical question, or maybe something that we can leave open-ended for now, but I think one of my thoughts or concerns about this is drawing the delineation between somebody who's practicing in their backyard, maybe teaching their family member how to use a weapon for the purpose of self-defense, compared to the platoon of people who are practicing to take over a state building. There's a big difference there. And so I guess my open-ended question is, how do we differentiate between those two? And I think that goes to the point that was brought up earlier about being really careful with the language and what we're incorporating in this.
Yeah, it's a good concern. And again, the intent is not to impinge on people's ability to use their weapons for self-defense. It's offensive training, coordinated, that sort of thing. So, but I hear you. If you've got 3 family members and you're all in the backyard and you're training how to, defend the home if somebody attacks, does that cross a similar line? So,
well, I do know that people call that area, Danby and Rupert, which I represent, there was concern about the behaviors towards the neighbors. And the frustration of the neighbors to not have the state government, including the state police, be able to do anything about it. It really took the town's attorney working on the environmental court to make the changes. And it was the environmental court that finally ruled there was a violation of environmental law. So, we need to get this right and make sure that we're not having unintended consequences. But for me, what I heard from those folks was a frustration with state government not being able to act to provide them with what they were considering very real threats.
Yeah. And I feel like in any other area, the state would assert its right to protect people. So it's admittedly, we're striking out a little bit into new ground, but as the witness will testify, it's something that, you know, a majority of states are dealing with and thinking about, because we're just in a different world than it used to be.
I think a lot of people are thinking about stuff like this, especially after January 6th.
Yeah. Well, and also the, you know, the intelligence that's been gathered at the national level suggests that attacks on the power grid have been, you know, circulating proposed attacks, chatter about attacks for 10 years. And they've now started to happen. And no one's demonstrated, to my knowledge, any real coordination among those attacks. But it doesn't take a big leap of the imagination to, with the use of the internet, to feel like that would be the next step. So proactive rather than reactive.
Yes.
One last question. The domestic terrorism statute that we have in place, I mean, is this something that would be germane to that statute instead? Because I know there's a provision involving threatening civilian populations and buildings. I can't remember the wording off the top of my head, but I mean, this seems like something that might be partially covered by that, but also changes that could be incorporated into that to prevent these certain types of camps from popping up.
I think that there's a conceptual connection for sure. So, and I think there might be areas of crossover.
Yeah.
At the same time, there's part of this I think is a bit distinct, the training.
Yes.
So, but in terms of where it's located in the statutes, if you move ahead with it, it might make sense to put it within that chapter, right? To make that sort of not reinventing the wheel sort of thing.
Are we ready for sure of court? Mary, thank you for joining us.
It's my pleasure. Thank you for having me this morning.
Let me just have the committee identify themselves, since you probably don't know any of us.
Yes, thank you.
Starting perhaps from Senator North.
Hi, Mary. Bob Norris, Franklin County.
Tanya Bihovsky, Chittenden Central.
Dick Sears, Bennington County.
Nader Hashim, Wyndham County.
And Phil Baruth, Chittenden Central. Nice to put a face to your voice, Mary.
Yes, thank you. So as indicated, my name is Mary McCord. I am the Executive Director of the Institute for Constitutional Advocacy and Protection, or ICAP, at Georgetown Law. We are actually a constitutional impact litigating institute. My background is in the Department of Justice, the U.S. Department of Justice. I was 20 years a federal prosecutor in D.C., and then I was 3 years in the National Security Division at Maine Justice, including as the Principal Deputy Assistant Attorney General for National Security, and then later the Acting Assistant Attorney General for National Security, and left the department in 2017. So I've focused a lot of my career on counterterrorism internationally, and have focused it in my career at the Department of Justice and now at Georgetown on countering the domestic extremist threat. Our institute has actually litigated against private militia organizations successfully in both Virginia and New Mexico using state anti-paramilitary laws, which I'm going to talk about today. But what I want to do, just because this is, I know, a new area for some of you, is talk first about sort of the constitutional history of prohibitions on private paramilitary activity, how that's also consistent with Vermont's own statutory scheme, and then talk a little bit about the existing laws that are out there, how this law might be strengthened, this bill might be be strengthened to address the threat. And, you know, I've also done a lot of speaking and writing about the escalating threat that you all have been talking about at the opening of this hearing, and I'm happy to answer questions about that too. I think concerns about the plots against the electric grid and things like that are very serious, and there's some good new reporting on that out of the George Washington University. But first, prohibitions on paramilitary activity go back historically to even before the founding. There is no authority. There's three things. If there's three things you can remember from this, it's that there's no authority under federal or state law for private militias or private paramilitary organizations. They're not protected by the Second Amendment. The Supreme Court's been clear for more than 120 years, and every state forbids them. So let me break those down. No authority under federal state law. Many times militia members will argue, well, well-regulated militia, there it is right in the Constitution. Throughout our history, we've been the bulwark against the tyranny of the federal government. But that is actually ahistorical, atextual, and contrary to Supreme Court precedent. History shows that even before the founding, even before the Constitution, the early colonies had militia acts. They did not want to have standing armies. So what they did for their defense is they had militias of all able-bodied men, and it was men at the time, between certain ages, who were available to be called forth by the governor in defense of the colony, and always reporting up through the governor. And that goes back to the late 1600s and 1700s in militia acts in Massachusetts, New York, and elsewhere. Clearly, though, always under the direction and control of the civilian authority, the governor. There was no authority for sort of rogue or vigilante militias or paramilitaries to oppose the authority of the state. And in fact, it was rebellions like Shays' Rebellion and other paramilitary activity against the state that actually were taken into account by the founders in writing the U.S. Constitution. The U.S. Constitution provides that Congress has the authority to provide for the organizing and disciplining of the militia. That's in their Article 1 authority of the U.S. Constitution. Congress has used its authority to enact militia laws dating back to the 1700s, which have provided ultimately over amendments into what is now our modern National Guard, a system of dual enrollment, state militia, National Guard units that can be federalized. Congress also authorized the states to have their own state militias, and Vermont has a state guard, Vermont State Guard, which the governor, again, the governor can call forth when needed in defense of the state. But there's no authority under the federal constitution or state constitutions for private individuals to organize themselves as their own paramilitary organizations, whether to forcefully oppose the government or to usurp the role of the government in law enforcement, security, etc. That was also baked into the constitutions of 48 states, including Vermont, which provides that the military should be kept in strict subordination to and governed by the civil power. That's in 48 state constitutions. So that's the first point. There's no federal or state authority for private militias or paramilitary activity. The second is that the Supreme Court has been clear since 1886 that it does not protect private paramilitary organizations. In 1886, in a case called Presser v. Illinois, the court upheld a state anti-militia statute, a statute that exists on the books of 29 states to this day, but not Vermont, which generally, the wording is almost identical state to state. It generally prohibits bodies of men from associating together as a military unit or a military company or parading or drilling in public with firearms. And when that was challenged back in 1886, the Supreme Court upheld that, and it said some important things, and I just want to read a couple quotes because I think these are so salient today. It said, military organization and military drill under arms are subjects especially under the control of the government of every country. They cannot be claimed as a right independent of law, and under our political system, they are subject to the regulation and control of the state and federal governments, acting in due regard to their respective prerogatives and powers. The court went on to say the exercise of this power to prohibit private paramilitary activity is necessary to the public peace, safety, and good order. Now, you may think, well, that's very, very old, but the Supreme Court as recently as 2008 in the case of District of Columbia versus Heller. This is the case which for the first time in our history, the Supreme Court held that the Second Amendment does protect an individual right to bear arms for self-defense. And I know you've been talking a little bit about self-defense this morning. The court, in an opinion written by Justice Scalia, pointedly contrasted that with private paramilitary organizations and private paramilitary activity, noting that no one arguing for the individual right had even questioned the authority of states to prohibit that, and reiterating that the Second Amendment does not prevent the prohibition of private paramilitary organizations. And you may be recalling that the Supreme Court this year, or not this year, we're now in 2023, in 2022 issued its first new Second Amendment opinion since Heller, significant opinion, and there's nothing about that opinion that calls into question the ability of states to prohibit private paramilitary organizations. So that's point two. Last point is it's unlawful in every state. As I already mentioned, 48 states have constitutional prohibitions on private militias by saying the military always must be strictly subordinate to the civil authority. 29 states have anti-militia laws. 25 states have an anti-paramilitary activity law that frankly goes to a lot of the things that I think Senator Baruth is looking for in this paramilitary training statute. These laws are in a catalog that my organization has put together of the laws of all 50 states, which I can share a link to. But that statute generally prohibits 2 or more people from assembling together to instruct, demonstrate, train, or practice in the use of firearms, incendiary devices, or techniques capable of causing bodily injury or death, knowing or intending that those techniques or firearms or incendiary devices will be used in or in furtherance of a civil disorder. Now, civil disorder is defined as generally a public disturbance involving 3 or more people where there are acts of violence and a risk of destruction of property or bodily injury. I will say that there's a statute like that also on the books of the US Code that prohibits that same type of training and practicing and instructing. That statute is, as I mentioned, active in about 25 states. It dates to the early 80s and was part of the Anti-Defamation League's legislative agenda when the KKK was opening up training camps in many places across the country in the late 1970s and early 1980s. There's almost a dozen states that prohibit the false assumption of the duties of law enforcement or peace officers, because as we've seen many times, paramilitary groups will sometimes come out and ostensibly protect private property or we've even seen them protecting statues. We saw that in Virginia with the protection of Confederate statutes, and really usurp the functions of law enforcement. And that is explicitly unlawful in nearly a dozen states. Other states prohibit the wearing of uniforms that are confusingly similar to military uniforms. So there's no state that doesn't have at least one of these provisions. In Vermont, it is the constitutional provision, but you do not right now, at least not insofar as I have been able to discern, have any other criminal law directed toward paramilitary conduct. Now, before I move on to what Virginia's scheme is for the regulation of this, I do want to mention that these state laws, as well as theories of public nuisance, were what ICAP used in representing the city of Charlottesville, local businesses, and local homeowners associations in a successful suit against 23 different unlawful paramilitary organizations and white supremacist organizations who were engaging in paramilitary activity during the Unite the Right rally in 2017. The court there held that under Virginia's Constitution, the provision, just like Vermont's, under its anti-paramilitary law, under its law prohibiting the false assumption of law enforcement, and under its public nuisance theories, had stated a valid case. And that case resulted, this was not a criminal case, of course, this was a civil case that resulted in court-ordered injunctions prohibiting that conduct. I'm sorry.
I have a question.
Yes.
Hi, Mary. This has all been very helpful information. And just before you go on to the next point, could you just remind me what the Supreme Court case was before you cited DC versus Heller?
Presser v. Illinois. And I don't have the site at hand, but I can, as soon as I finish speaking, I can put it in the chat or send it to you. I have it
Thank you.
written in so many different places, but not in my notes for today, and I apologize for that. It's 1886 US Supreme Court.
Thank you.
We also successfully, just this past year, worked with an elected district attorney in New Mexico to bring a civil enforcement action, again, under its state constitutional provisions, state laws, and public nuisance theory against an unlawful private militia there who had deployed out during some racial justice protests in 2020, heavily armed. In many of these cases, we're seeing, AR-15s, full military kits, flak jackets, combat helmets, and, operating under a command and control structure. And again, we relied on state law and were successful in court there and obtained court-ordered injunctions against that organization. So, and we are not the first to do this. Back in the early 80s, the Southern Poverty Law Center and other lawyers brought cases against the militia wing of the KKK in both Texas and North Carolina, which were also successful on these theories. It's just that then we went in a very long dry stretch of them not being used and falling out of the memory of most law enforcement at the same time, while a real mythology about the Second Amendment was developing throughout this country that has led many people, including in some cases law enforcement, to actually misunderstand and think that the private paramilitary activity is protected by the Second Amendment when it is most definitely not. So moving to sort of Vermont's statutory scheme, and I'm certainly not an expert in Vermont law, all of you there, and of course your alleged counsel are much more expert, but I just want to point out some things that are very consistent with prohibitions on private paramilitary activity. First is the constitutional provision I mentioned that requires the military always to be kept in strict subordination and governed by the civil power. Second, your statutory scheme sets forth how the military is organized. It's under Title 20 of the Virginia Code. It says the organized militia of the state is the National Guard. It's organized in accordance with federal regulations approved by the governor. The National Guard under Section 601 may be called out by the governor into camp for instruction and drill, or the governor's designee, the lieutenant governor or adjutant general. And that when the National Guard is in federal service, if it's called up for federal service, the governor may organize and maintain a military force as necessary for the defense of the state, known as the Vermont State Guard. But again, always subordinate to the governor and the adjutant general, and there's no authority in Vermont's scheme for private individuals to form their own militias or paramilitary units. So moving now to the statute that we're talking about, I would say that the bill that has been submitted is consistent with the anti-paramilitary activity laws I was talking about in these 25 states. I do think it would probably be improved by the addition of a knowledge or intent requirement, because some of your questions have indicated what about sort of private activity on training in the safe handling of weapons, or shooting drills with your family on private property. I think it's implicit, I think, in the language that the concern is this is training for deploying this action out in public, but the intent there could be made more clear. Now, the 25 statutes that exist that I talked about a few minutes ago, the intent required there is either knowledge, reason to know, or intent that the training be used in or in furtherance of a civil disorder. Now, I say in or in furtherance because I think that's important. In furtherance would suggest that you're wanting to create the civil disorder, but in could be we're training because we want to take up defensive positions if others create a civil disorder. And that is really the role of law enforcement or your own National Guard, not the role of private paramilitaries. That said, that statute has been rarely used and it is relatively clunky. And even though we used it to bring civil suits, it's technically a criminal statute. And I do think it's important for there to be some civil enforcement mechanisms within statutes. I noticed the bill that's been introduced also is a criminal statute, I think appropriately, but you might want to consider civil enforcement mechanisms. The model bill that I shared with Senator Baruth is based on a model federal legislation that I've been working on. My team has been working on with Congressmember Jamie Raskin, as well as others over the last year or so, to potentially introduce at the federal level, because as many of you know, a lot of paramilitary organizations, and this was certainly shown on January 6th, travel, right? They cross state lines, they bring their weapons, and they go deploy in other states. In fact, in Charlottesville, where we brought our lawsuit, there were private militias that had come from as far away as the state of Washington, all the way to Virginia, as well as many in the Northeast and the South and elsewhere. Almost all of them there, frankly, had come from other states. So it is, I think, an interest of federal concern, but that doesn't mean states ought not be looking at it. The way we've structured this model bill builds the knowing and intent element right into the action that is prohibited. So it prohibits any person from knowingly, while acting either as part of a paramilitary organization or on behalf of or in furtherance of the objectives of that paramilitary organization, from while armed with a weapon, a firearm, or any dangerous weapon, to publicly parole or drill or engage in techniques capable of causing bodily injury or death. So it's pulling from some of the existing laws that have been upheld. Interfering with or attempting to interfere with or interrupt government proceedings or government operations. So that's targeted at things like, you may have seen examples of private militias, even before January 6th, where of course they interrupted government operations. We saw similar activity in the state houses of Michigan and Idaho and elsewhere. We now are seeing them sometimes in county board meetings, school board meetings, etc. Would also prohibit them from asserting authority over others without consent. That's getting at that exercising law enforcement functions, and interfering or intimidating with other people's exercise of their constitutional rights, whether it's their right to vote, their right to engage in free speech, public peaceful assembly. And it would prohibit training to do any of those things. So you're incorporating that intent requirement into the training, because it'd be training to do these things in public. And the way we defined paramilitary organizations in this model statute is a group of 3 or more persons who are organized under a command and control structure to function either as a combat support, law enforcement, or security services. And this was drawn after consulting with some military experts and sort of like how they thought this would best be phrased. And the last thing I'll say about this model bill is that it includes criminal penalties, but also civil enforcement mechanisms, so that a state attorney general or district attorney could bring a civil enforcement action to get injunctive relief against this activity, including the training. So it would apply to the type, I think, of training camps that Senator Baruth's bill is targeted at, but would also apply when the activity they train for, they actually deploy in public. So the main weakness I see in the current bill is that it's just directed at the training and not what they do when they actually come out and engage in this activity. So this, just so that you'll know, this bill, a version like this is being introduced right now in the Oregon State Legislature. I've also just in the last few weeks had conversations with legislators in other states who are interested in it or a version of it. So, and as you know, there are already a plethora of existing laws, but this one we've tried to really tailor to be more useful to law enforcement and more useful to on the civil side as well. Oh, I should also add one last thing. It would also allow a private cause of action for a person injured by the unlawful activity, so that, if someone is shot or injured or intimidated, they would have recourse. And with that, I'm happy to take any questions you might have. I'd be happy to work with you, by the way, on tailoring this model or your legislation to, the specific needs of Vermont.
Thank you so much, Mary. That was fantastic. I have a question about the model bill. So if I'm understanding your information, you're saying that there are existing statutes that have been upheld by the courts. But the model statute that you sent is new but drawn from those previously upheld?
Yeah, so what we've done, the anti-militia bill that was upheld back in 1886, it's really old, and it's been upheld multiple times at the state level and the U.S. level. I say multiple times. It hasn't been challenged that many times, but when it has been upheld. But it's not the easiest for a law enforcement to use because it doesn't define terms, and so it's in need of modernization. But we wanted to draw from what the Supreme Court has, given its stamp of approval to, which is partly why I read those excerpts from the Supreme Court decision. It's clear that the Supreme Court views paramilitary activity and paramilitary organization as solely within the prerogative of governments to regulate. And then the other thing we've done, and this partly draws on my lengthy history as a prosecutor proving cases in court, is try to be specific enough with the provisions using action verbs about the conduct that is being prohibited so that it could withstand challenge, not only constitutional challenge, but vagueness challenges and other challenges is like that. The anti-paramilitary activity bill, the one that 25 states have that is more directed at training, has been also used and upheld in civil cases, even though it's a criminal statute. I've seen it used very rarely in criminal cases, although it was just used in Michigan recently. Successfully on the criminal side. And so again, drawing on that activity, but not wanting to limit it to training, that's where we've sort of created, after a lot of thought and a lot of research, this model bill.
And just finally, if we wanted, so we have your model modernized bill.
Mhm.
If we wanted an example of the best of those existing 25 that have been upheld, what state or what example should we look to?
Most of them are very, very similar. And I think you could look at Virginia's just as an example. It's the one we relied on. And I will also say it speaks to, as does our model bill, the exceptions. I know that's a concern, and it's a real concern that there definitely need to be exceptions for authorized activity and for reenactments and even parades by veterans associations and things like that. And so those types of
could you email me that link? Could you email that?
Right now, this is a link to the catalog of the 50. If I can, everyone in the meeting.
Yeah, could you email it to me?
I absolutely can. What I can do is email a number of resources, including some historical research in a paper that I drafted about the Second Amendment. I can email a plethora of resources. Should I email to maybe Peggy to distribute them?
That would be great. Thank you.
I have a question. How many people, what's the minimum number of people? And would all members of this come under it, or just a leader?
So it would apply to all who are participating in it. And are you talking about the existing laws? The model bill. So it is talking about any person when acting as part of an unauthorized paramilitary organization or on behalf of or in furtherance of that organization. The reason for the on behalf of or in furtherance is sometimes what you'll see, and we certainly saw this on January 6th and in Charlottesville, is that in their home states, they're part of an Oath Keepers chapter or their own, militia with whatever its name might be, the American Defenders of Freedom or a 3% chapter or what have you. And many times they'll then travel and join up at a particular event, and they'll designate someone as the commander. This happened in Charlottesville. There were, about a dozen different paramilitaries who came, and they all designated the leader of the Pennsylvania Lightfoot as their commander for their day, and the leader of the New York Lightfoot as their deputy commander for the day. But there were militia members from a bunch of different militias. So the idea there is if your whole militia doesn't come, but you join up with others and you are engaging in this paramilitary activity, this would apply to you. And so for the minimum number, then that part of the paramilitary organization is defined as 3 or more. So any group of 3 or more persons associating under a command structure for the purpose of functioning in public or training to function in public as a combat support, law enforcement, or security services unit.
Thank you. That's helpful. Other questions for Mary or comments?
I guess one last thing. I was thinking back to what you had said, and I think you actually may have already covered this, but I was looking at the Vermont Constitution as well, and Article 16. Do you feel that pretty clearly and explicitly says that paramilitary organizations that are not under subordination by a civil power, that those are not covered by the Constitution, the Vermont Constitution?
That's right. And part of this goes back to the original provision comes from the Virginia Constitution, which was the first. And there has been historical research done about that provision. And, many of the other state constitutions literally just lifted that provision from the Virginia Constitution. And there's historical research about that provision, that it was really intended to make sure there weren't, it had two intents. They didn't want standing armies. That was a big fear at the time of the founding. So they wanted the governor to be in charge of the military of the states. And secondly, they didn't want rogue or vigilante or alien soldiery to be a threat to the state. And that's the part that, we're really relying on when we're talking about no rogue militias. That also, I think, has to be read, consistent with what then happened in our US Constitution, and which gave Congress all of the authority over organizing and disciplining the militias, and has enacted its own militia acts under that US constitutional authority.
And last question, and this goes to a question that I asked earlier, but do you find that these sorts of bans on paramilitary camps are incorporated into domestic terrorism sections in different states, or do they tend to stand alone in the criminal statutes?
I have not looked at the placement in every state. I have looked at domestic terrorism statutes, and they exist in about 25 states, and they're also all modeled pretty similarly, and they also tend to follow the federal definition of domestic terrorism. There's not a federal generic domestic terrorism statute, as you may know. I don't know, but I can't answer your question right now about whether these things are typically together. In some, they definitely are. In some, I've seen they actually come under the label of domestic terrorism, and this anti-paramilitary activity law is there. So some have definitely done that, but I can't say if all of them has. I don't, your Vermont's domestic terrorism statute does require an act of violence, right? That it has a little bit a different intent requirement than some of the others, which it includes the intent to intimidate or coerce the civilian population or affect the policy of government through intimidation and coercion. I didn't see that when I quickly looked at Vermont's statute, but it applies to engaging or taking a substantial step to commit a violation of the criminal laws of the state. And then it's just with the intent to cause death or serious bodily injury to multiple persons. And it doesn't require that intent to intimidate or coerce. So yours is actually broader than many of them. It would apply to a mass shooting, even when we don't know what the intent of the shooter was. And so, so there's, right now, I don't see overlap in terms of the prohibitions of these things, of these two different bills, but I don't think I don't see any harm to locating it in that area of the code. There might be other places that are better, potentially where you have other gun regulations or something like that, but I have not studied your code enough to know the best placement.
Thank you. Any other questions for Mary? Mary, thanks so much for joining us. Very helpful, and appreciate your testimony. Our next witness is Russ Lane, a citizen of Danby.
Yes, thank you. I also want to say that I appreciate Mary's comments. It certainly was an eye-opening lesson, and I appreciate the work that she does. I'm a private citizen here in Danby. I live in the part of Danby which is pretty close to Paulet, so the concerns of what was happening over there in the Bonnier enterprise was a concern of mine, even though I'm only about 5.5, 6 miles as the crow flies to that locality. But that's enough to have concerned me. But my is that as a resident, and I've been a resident here for 5 to 6 years, and I've learned through some of my neighbors and some of the people that I've had a chance to speak with, is that Danby doesn't have any zoning, and so that the situation of another militia, wanting to find a site to practice their militarism, might very well be here in Danby, where we don't have any zoning that would, would. So that's just my comment. I also want to thank Senator Baruth for having initiated this, and I think that if something comes down from the state level, it would make me as a private citizen feel much more comfortable about my situation here in Danby.
Thank you. I guess because I live in southern Vermont, I'm fairly familiar with the news reports, but and did hear from several of my constituents as well regarding similar concerns as yourself. But I wasn't aware that Danby didn't have zoning. So I appreciate you bringing that up.
Yeah, well, thank you for your effort.
And I was just gonna point out that takes us back to what seems to me a sort of discouraging state of affairs, where we're depending on environmental courts and zoning in cases where, we have live ammunition being fired and neighbors feeling threatened, and training for the kinds of activities we're talking about. So
Thank you, Russ. Appreciate your testimony and appreciate you joining us this morning.
Thank you.
Our next witness is Dave Hazelton, Chief Rescue Incorporated. Welcome, Dave.
Good morning. So Drew Hazelton.
Oh, I'm sorry. I called you Dave, and that
That's
shouldn't
okay.
be. That's an easy one. I guess my eyes are fogging up because of the mask. Use that for an excuse, Dave. Drew, sorry.
That excuse has worked for a couple of years. I'd stick with it. So Drew Hazelton, I'm the Chief of Operations at Rescue Inc. I also Vice President of the Vermont Ambulance Association and Chair of Vermont's EMS Advisory Committee. And my comments are actually very simple compared to the depth of the discussion you're having. And it's really in the exclusion section of the bill that's been introduced. And the exclusion section specifically calls out a municipal fire, and it does not actually have any room in it for EMS. And I thought it was important to make sure that you were aware that a lot of the fire service in Vermont is actually private nonprofits that are serving our communities. And the way that the bill is currently written, they would not be able to practice for and train for some of these horrible active shooter events. And there's no provision for EMS. Here in Southern Vermont, we actually have recently opened a EMS Academy. One of the programs that we teach is what we call TCCC, or Tactical Combat Casualty Care. And the purpose of that is to train EMS providers to utilize ballistic equipment under less than ideal circumstances to treat casualties during one of these horrible events. And right now there's no carve out to allow that type of education to happen in the EMS world. So that was my my purpose for asking to speak, and I guess I'll answer any questions.
Senator Bruce.
I'll just say that it was very much our intent to try to exempt everybody like EMS. We didn't happen to mention it specifically, so I'm very happy you brought it forward, and we can add that to whatever we do to make sure that your activities are protected. Similarly, we were thinking about the whole range of first responders, but we need to make sure that they're listed explicitly.
Thank you.
Any other comments or questions for Drew? Drew, thanks so much for joining us.
Thank you.
Good seeing you, Drew.
Billy Clark is our next witness. He's a litigation attorney with the Gibbons Law Center to prevent gun violence.
Thank you so much for the introduction, Senators, and thank you for having me here today. So pleasure to speak on behalf of the Giffords Law Center to prevent gun violence and to touch on many of the things that Professor McCord already ably addressed. So I will try not to repeat matters, and I will be able to bring Vermont focus to it because I actually live and work in Vermont. I'm a licensed attorney in Vermont, worked previously for Downs Racklin Martin, and before that was a federal law clerk for judge in the District of Massachusetts, and then for the Court of Appeals for the First Circuit in Boston. And also Senator Baruth, I am a proud English major from UVM and also got my master's in English at UVM. So very excited to be before you in a different role today.
We always like to see people gainfully employed after they get an English degree.
Well, two English degrees to boot, you know, so I was really doing myself in. So very excited to be able to, yes, have a shirt on my back. So I'll start, because Professor McCord already ably addressed sort of the Second Amendment issues with Presser. I also can provide the citation to Presser v. Illinois, which is 116 U.S. 252 from 1886. Again, that's 116 U.S. 252, although I'm sure it'll be in the many materials that she sends along after. But I did want to at least briefly address Vermont law to start, because I know there was a question raised about Article 16 and the way that Article 16 would work with paramilitary organizations and private militias. And actually, the very recent decision of State v. Mish from 2021, which upheld Vermont's large capacity magazine ban, includes a lengthy discussion of the history of militias in Vermont and the role the militias played as a subordinate entity of the state. And paragraphs 22 and 23 of that opinion, which can be found at 2021 VT 10, go into the sort of false narrative that these modern private arms groups, and as the Vermont Supreme Court rightly recognized, often, quote, militant white supremacist organizations try to claim the title of militia, when in fact, quote, there is no modern equivalent to the universal state-regulated militia known to the framers. And to the extent that the right to bear arms is tied to the purpose of supporting services in the state militia, this aspect of Article 16 has little meaning in today's world. Again, that's at paragraphs 22 to 23 of the opinion there. I would also note that in State v. Mish, the Vermont Supreme Court adopted the reasonable regulation test for considering challenges brought under Article 16. And under that test, a court will uphold a statute implicating the right to bear arms, provided it is a reasonable exercise of the state's power to protect the public safety and welfare. So this is a test that gives a little bit more leeway and holistic consideration, not just of historical precedent, which I'll get to in a second with the new test that's come down from the Supreme Court in Bruin, but also allows for public safety considerations and many of the concerns that have been discussed today. So I think there's very little chance that any statute going after paramilitary organizations could face a realistic lawsuit under Article 16 or a realistic challenge under Article 16. So again, I don't want to repeat what Professor McCord ably said about Presser and about District of Columbia v. Heller. I will go a little bit into the Bruin decision because that is now the new test for evaluating Second Amendment challenges. It's something that we as an organization are litigating daily and filing amicus briefs in support of daily. So I do want to sort of talk through what that looks like as a general matter, and then how I would see that test applying to a challenge that would be brought to a regulation of private paramilitary organizations. So the Supreme Court described the test in Bruin as follows, quote, when the Second Amendment's plain text covers an individual's conduct, the Constitution presumptively protects that conduct. The government must then justify its regulation by demonstrating that it is consistent with the nation's historical tradition of firearm regulation. And I know that's a little wordy, but that is that test language gets repeated a couple of times in the opinion. And so I do want to flag that as sort of the central inquiry. And how does that get broken down? Now that The Supreme Court rejected what had been the almost universally accepted test for considering Second Amendment challenges, which allowed for consideration of public safety interests and what's called means end scrutiny for the lawyers, the typical tiers of scrutiny, intermediate scrutiny, strict scrutiny, and what have you. And the Supreme Court rejected that test and adopted the test that I just set forth. Now, the way the courts have been applying it since the decision came down in June is a little all over the place, but we're starting to see some trends. So the first part of the test is, does the Second Amendment's plain text apply to the conduct that's at issue? And is the person who's bringing the challenge a part of the people defined as having Second Amendment rights? So that's the first step of a challenger would have to show that the proposed course of conduct that they're looking to engage in or that they have engaged in is protected by the plain text of the Second Amendment. So if they meet that plain text step, that first step, it then goes to the government to show that the regulation that's at issue is consistent with the nation's historical tradition of firearms regulations. So that's the second step, and that's where, as I'm sure you've heard in the consideration of other gun bills in this area, where there does need to be a focus on history and a focus on historical laws that have been passed and historical attitudes towards different regulation of firearms. So to go to the private paramilitary organizations, I think what we have here actually is a place where a challenge would fail at the first step, at the plain text of the Second Amendment. Because as Professor McCord so ably said, the Second Amendment does not protect a right for the proposed course of conduct, which would be to engage as a paramilitary organization, to organize as a paramilitary group, is simply not covered by the Second Amendment. That's not what the Second Amendment is about. And Presser v. Illinois is pretty clear about that. And Presser v. Illinois was just recently reaffirmed in DC v. Heller. So that would be the first step inquiry. A person bringing that challenge would likely a court would, in my view, likely say, this is not protected by the Second Amendment's plain text, and I don't even have to consider history. Although, of course, if we go to step two, if a court did assume for the sake of deciding that this was protected by the Second Amendment's plain text, at the historical stage, again, as Professor McCord described, there's ample history supporting regulations on private paramilitary organizations, including complete banning of them, because they're simply that's not consistent with our history. It actually is, it's abhorrent to our history. There could be excellent statutes that I'm sure Professor McCord will provide, and also, I would point to the many, KKK statutes that were passed in the post-Civil War. There's, as she discussed, state constitutions that talk about the role of the militia and how it's not to be done in this, freestanding private way. So I think at both steps, it would the law would be upheld. Of course, as we've discussed today, the proof is always going to be in the pudding and the exact wording of the law. But as a general matter, I would say there is no Second Amendment right to engage in paramilitary activity. So those are the main points that I wanted to make. Let me see. As to the bill itself, there's 2 points I would add on. Professor McCord talked about having a civil enforcement mechanism. I would completely agree that having some sort of civil enforcement mechanism would be good. I think also specifying that injunctive relief would be available would be helpful. I think to go to the example of Slate Ridge, if the neighbors could have obtained a preliminary injunction or a TRO preventing that sort of conduct from the outset without having to go through the environmental court, that would have been a far more efficient way that could have then been enforced by the sheriff and local police. So that would be one thing I would say. The other thing I would consider, and again, this is going to sort of depend on where the bill goes, but you may want to consider making this conviction a crime of violence that would make a person who's convicted of this crime a prohibited person from possessing a firearm under state law. There are many different crimes of violence that are listed in. I've got the site in front of me, where is that? I believe it's at 13 VSA 4017. So you could consider that. As of now, it's a misdemeanor. And I know that some comparisons have been made to the domestic terrorism statute, which is a felony which carries up to 20 years in prison. And so obviously.
Can I interrupt you real quick?
Of course, yes.
Sorry to disrupt your flow.
No.
I just didn't want to move on too far. I was wondering if quickly we could go back to the plain text.
Yes, absolutely.
For this, and on the U.S. Constitution, it's the phrase is a well-regulated militia. are you interpreting that as, a well-regulated militia being governed by state government and reporting to the governor the way we've heard earlier from this court?
Yes, that's how I'm interpreting it, and that's how the Supreme Court has interpreted it, even recently in the DCV Heller decision. And I can get the
what was that decision?
yeah, the Heller. So yeah, just the final point there was, yeah, you could consider making it a prohibited person crime. Those have also been upheld after Bruin, challenges to prohibited person crimes. Again, because this would have showed that someone is inclined to, engage in dangerous activity. That's something you could consider. We as an organization are always concerned about labeling people as prohibited persons, given the inequities that can arise in the criminal justice system. However, I think with a law like this, there could be some sense to be made from doing that. So that's just one other suggestion I would add. But happy to discuss any other points on Bruin or any things with this bill.
I have one question. I'm thinking of where we have military groups who actually go over and fight in Ukraine right now, and they're from the United States. They may be together. I'm sure that we wouldn't want an unintended consequence of banning that. Or maybe some would, but I don't. And I'm wondering if that's a distinction, or am I just looking for unintended consequences and don't have one?
Well, Senator, I think this is an area to be very careful of unintended consequences. And I do think that another one of the points Professor McCord's raised about a scienter requirement, about having some sort of knowledge requirement in there, would assuage some concerns about, any of the, slippery slope arguments or unintended consequence arguments that we've heard today. Because I do think that, yes, there are many different ways where people, and we want to encourage, people training with firearms. We want to encourage responsible gun ownership and gun safety. So we want to be careful to not have unintended consequences.
And my understanding of, I think what you're getting at is that those individuals go to the conflict zone as individuals, and then they hook up with the command structure there and volunteer to it. They don't form a unit here and then go over. So if they were forming a unit here, even if they said, we're training for warfare in Ukraine, I would still want to prohibit that, because that's something that only the military should be doing. But if they, as individuals who are retired from the military or whatever, there have been a lot of cases of individuals going over to Ukraine and they volunteer and then they are put into a unit. I don't think this would affect that.
What I'm hearing is if we put a knowing standard in, that would allow.
Yep.
Yeah, and one other point on the scienter that I would make, the way that the bill is currently phrased, I know there may be different iterations, but it talks about own or operate, and I do think that the scienter for owning is particularly important, because operate to me implies at least some active participation in operating in the instruction facility. Owning, I could see a person leases out a property to someone who then decides to open up a paramilitary organization. It could be, some unintended consequences of liability on a property owner in that way. So that's, again, where I think adding scienter would alleviate a good deal of the concerns.
Mm-hmm.
Any other questions?
I got one, Senator.
Yeah, Senator.
This is probably a much more lengthy conversation, or is it? And I was getting close to lunchtime here, and I hate to be the guy that raises his hand. During the course of all this, Billy, has anyone ever brought up, and I know Senator Bruce, you can blame him for this, because it gets me to think about this, has anyone brought up or mentioned the Posse Comitatus Act of 1878, how this may or may not apply to this?
I don't believe it's been brought up yet.
Well, it has now.
It has now, absolutely.
And it may not have any bearing on it. I'm just, as you well know, it's an old English law. I become familiar with during my terms here, whatever else. I don't think it's ever been initiated, but I know it's been talked about in our more recent presidential, our last president, I believe, which is, we'll just leave it at that. I'm just wondering if, I mean, this is some group that could, civilian group that could basically train under your local sheriff for, as a group, to address civil discourse or civil arrest or whatever. But they're civilians. And I think, like I said, I don't want to drag us well past our lunchtime.
Question, because, good, go ahead.
I was just going to say that I see Professor McCord in the chat says she'd be happy to discuss. So I'm more than happy to pass it back over to her on that point, because I don't have any developed thoughts on that, but I do think it's an
We've
interesting.
got about 5 minutes left if Mary is still with us and wants to comment on it.
Sure. I mean, the Posse Comitatus Act at the federal level is really about the prohibition of federal troops from engaging in domestic law enforcement activity. And so I don't think that has any intersection here with prohibitions on private paramilitary activity. I think what you might be getting at is what about sort of the historical use of posses usually by sheriffs as opposed to modern police forces, when they needed to supplement their own deputies. And I haven't studied Vermont's laws on this, but in most states, that is also, there's still the ability for sheriffs to deputize members of the public to engage in certain law enforcement, but it's regulated by the state. In many states, that requires the posting of a bond, it requires particular training, et cetera. And so one thing about, now this I don't believe is in the draft bill, but in our model bill, one exception is for any authorized paramilitary activity authorized by state or federal law. So if the committee or if the legislature were to, want to move forward with something like this, part of the exceptions could be authorized, activity authorized by federal or state law. But there's nothing in your state law that just allows private citizens to do this kind of training in order to be able to engage in the activity outside of the authority of the government.
So if we're looking for historical context, there's Remember Baker from Arlington, Vermont, who was taken by a New York posse back before Vermont was a state. And we now have a plaque in Arlington remembering Baker, and I attended that last summer. So I would ask people to look at Remember Baker if there's a historical context to the posse. I'm glad you brought that up, Senator. And we don't want any more Vermonters being attacked by New York posses.
It's just an old law. So.
Well, but it could come up, if your Ron decision is looking at historical context, there it is. Thank you all very much.
Thank you, Billy. Thank you, Mary.
And I'll leave you all to